Welcome to the Deep Dive. This is the show where we take dense information, slice it up, and find the most important insights just for you. We're continuing our journey through the Manual of Patent Examining Procedure, the MPP. Today, we're opening up Chapter 700, Examination of Applications. This gives us the core playbook for how the USPTO reviews patent applications.
Exactly. And our mission in this deep dive is to unpack a really critical piece of that playbook. MPP Section 717, that's the one titled Prior Art Exceptions under AIA 35 U.S.C. 102B1 and 2. Understanding this is, well, vital if your application is examined under the first inventor to file rules of the American Invents Act, or AIA. It's all about preventing certain types of disclosures from, derailing your patent application.
Right. Think of it as navigating a minefield, and Section 717 gives you the map to avoid stepping on what looks like prior art, but legally isn't, against your specific invention under the AIA rules. So let's unpack this.
Okay, so under the AIA framework, prior art rules changed significantly. We moved away from the old first to invent system. Generally speaking, almost anything publicly available anywhere in the world before your effective filing date can be considered prior art under 35 U.S.C. 102.
Wow, that sounds incredibly broad. So if I disclosed my invention publicly, even, like, briefly, would that automatically block me?
Not necessarily, and that's precisely why 35 U.S.C. 102b exists. It carves out these crucial exceptions to the 102a rules, recognizing that, well, some disclosures shouldn't count against the inventor, provided certain conditions are met. The first major exception under 102b1 deals primarily with disclosures made by the inventor or derived from the inventor. What's fascinating here is that a disclosure made 1 year or less before your effective filing date is not considered prior art
If it was made by the inventor or by someone who obtained the subject matter directly or indirectly from the inventor.
Okay, so if I publish an article about my invention, that's not automatically fatal if it's within a year of filing. Correct, provided you were the source. And the section also describes another layer. A disclosure made by someone else, something that might otherwise qualify as prior art under 102A1, is not prior art if you, the inventor, had already publicly disclosed the subject matter before that other person's disclosure.
Ah, okay, so that protects you.
It effectively preserves a grace period triggered by your own prior public disclosure.
Right, right. This prevents situations where, say, a coworker or someone who heard about your idea makes a disclosure, and that disclosure then becomes prior art against your later filed application, even though it came from you originally. That's really interesting.
Precisely. This exception shields inventors from losing rights due to their own early public disclosures, or maybe derivative disclosures made by others, as long as it's within that 1 year grace period and, attribution can be shown. It's about preserving the inventor's ability to get a patent even after some pre-filing activity or accidental disclosures.
Okay, that makes sense for things like articles or talks, but what about prior art from other patents or published applications?
Good question. That brings us to 35 U.S.C. 102b2. This section primarily provides exceptions to disclosures that would otherwise qualify as prior art under 102a2.
And 102a2, prior art, that's generally a U.S. patent application publication, or maybe a WIPO publication that names a different inventor entity and has an earlier effective filing date, right? I think I saw that in the MPP sources.
That's correct. So 102b2 then says these types of documents won't be considered prior art under 102a2 if, well, a few conditions apply. First, similar to the first part of 102ba2, if the subject matter was obtained directly or indirectly from the inventor. Or, again, if the subject matter was already publicly disclosed by the inventor prior to the effective filing date of that 102a2 document. So your own prior public disclosure provides a shield here, too.
Okay, so my earlier public disclosure protects me against later publications and later filed patents applications from others.
If they disclose the same subject matter, yes. And then there's a really important third part, specifically 102b2c. This one states that the earlier document isn't prior art if the claimed invention and the subject matter in that 102 document were commonly owned or subject to a joint research agreement by the effective filing date of the claimed invention.
Ah, common ownership. That's huge for companies, isn't it? It means related patents or publications from within the same organization don't automatically become prior art against each other under 102a2.
Exactly. It stops a company's own internal R&D pipeline, where different inventors might contribute or file related applications, from kind of creating prior art against itself. It recognizes that collaboration happens within entities, and those related filings shouldn't necessarily be used to reject each other. And yeah, the MPP points examiners to Section 770.02 and onwards for the nitty-gritty on this common ownership part.
So how do you actually tell the patent office that one of these exceptions applies? It sounds like you'd need to provide some proof, right?
You absolutely do. The MPEP specifies that 37 CFR 1.130 is the key rule for operationalizing these exceptions. It allows applicants to submit affidavits or declarations. These declarations are used to establish, the origin or timing of a disclosure. For example, if you publish that article 6 months before filing your patent application and the article names only you, the inventor, you could submit a declaration under 1.130 explaining this, linking the article, showing the date, and it might be excluded as prior art.
Or that example you mentioned before, if a coworker published something derived from me, but maybe inadvertently?
Right. You could use a 1.130 declaration to show that the disclosure originated with you, or perhaps that your public disclosure predated theirs.
So the declaration is the formal way to get the evidence to the examiner.
Precisely. It's the mechanism. Our sources also mention you can submit these affidavits sometimes when you reopen prosecution, like doing an appeal. But the rule does have its limits. A 1.130 affidavit is ineffective if the disclosure you're trying to accept happened more than 1 year before your effective filing date. That grace period is absolute. And also, if the issue is whether one inventor actually derived the invention from another inventor entirely, which is different from just a disclosure appearing as prior art, that needs a separate derivation proceeding under 37 CFR 42.401. You can't use a 1.130 declaration for that kind of inventorship fight.
Okay. So boiling this all down, what does this really mean for someone navigating the patent process? Why is getting your head around Section 717 so critical?
Well, understanding these exceptions is absolutely vital. Honestly, it can make the difference between your invention being considered patentable or getting rejected based on prior art that, legally speaking, shouldn't even apply. It really highlights the delicate balance under AIA law between public disclosure and preserving your patent rights, proper timing of your filings relative to any public disclosures, and keeping clear records about the origin of any early disclosures. It's just critical.
Timing and clear attribution, those sound like the two absolute key takeaways here.
They really are. Ignoring these rules, or just failing to properly document the circumstances surrounding a disclosure that could fall under these exceptions, can lead to unnecessary rejections. Or worse, you might find you can't get a patent at all, even if you were truly the first inventor. It also underscores that even though the AIA moved to a first inventor to file system, the inventor's activities and the origin of disclosures still play a huge role in figuring out what counts as prior art against them. And, keep in mind, applications claiming priority to older pre-AIA applications might still bump into some nuances of the old rules, like pre-AIA 102G in certain situations.
Navigating the MPP, especially sections like 717 with its layers of exceptions and rules like 1.130 for documentation, it really shows the complexity involved in patent examination.
It certainly does. It's a system trying hard to balance encouraging innovation and public disclosure with protecting the rights of inventors.
And knowing how to use these exceptions and the tools like the 1.130 affidavit to prove you qualify is clearly essential for preserving those rights.
Which kind of leads to another interesting thought. If the system provides these detailed rules for applicants to exclude certain things as prior art, how does an examiner ensure they're applying them correctly? What does that process look like from their side when they get one of these 1.130 declarations?
Yeah, that's a great point to think about. What scrutiny does that evidence receive? Before we wrap up this deep dive, we want to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series.
And just a quick reminder for everyone listening, this summary of the MPP was generated using AI tools. It's for general educational and informational purposes only. It is definitely not legal advice. Always consult the official MP, a qualified instructor, or a registered patent practitioner for authoritative guidance.
Thanks for joining us for this deep dive into MPP Section 717. We hope it's given you some valuable insights into how the AIA prior art exceptions work. Stay tuned for our next exploration into the MPP.